Hey everyone, I'm here today with Jessica Levinson, constitutional law professor and wearer of many hats actually at Loyola Marymount Law School and MSNBC, to talk about the abortion case now making its way from the district court in Texas up to actually the Supreme Court of the United States. So very quickly, to set the table, we had this quite, I would say, dubious and suspect decision by Matthew Kacsmaryk in the district court in Texas. And it went up to the Fifth Circuit, and that's where things technically stand. The Fifth Circuit has granted a kind of crazy half stay, and I think that's the latest. The latest is the Department of Justice has understandably said this won't do and is going immediately to the Supreme Court. But anyway, Jessica, who's also a good friend of the podcast and will be doing some of these YouTubes in the future, has agreed to join us to talk this one through. So, as always, Jessica, thanks for being here.
Harry, I love being here. And, as you were setting the table for this conversation, I actually just taught the Dobbs decision last night in my constitutional law class. That, of course, as I think people who are watching know, that was the decision in June where the Supreme Court overturned Roe v. Wade. And they said that there is no longer constitutionally protection for the right to obtain an abortion. And I focused with them for a minute on the idea of what the majority said, which is now the federal judges, the judiciary is out of the business of abortion litigation. We've decided this and we're done. And I said, has anybody heard about mifepristone? And so that, I think, Harry, brings us
Yeah,
to
really.
today.
Yeah, no more shall we have to, walk down this troubled road. And of course, it's been just the opposite because, you and others said this at the time, including me. There are advocates out there that are going to be pushing, 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 and one of them pushed more to Judge Kacsmaryk, who was handpicked for this job. But let's go before we double back to him. Tell us what the Fifth Circuit stay is pretty confusing. So can you explain it and then give a sense of where the Department of Justice seems to be?
So this really is a half stay by the Fifth Circuit. And what we have here is that they're allowing a portion of the trial court decision to go forward, but they're pushing pause on part of it. And so essentially what this means is that the FDA's initial approval of mifepristone in 2000, that still stands. The trial court judge who wanted to suspend that is not suspended right now as the case continues to move through the court system. But
In other words, it's still valid. It's as if that part of it is operative law, at least while the case is decided, the 2000 part.
Exactly right. But we kind of then stop in 2015 because in 2016 and then again in 2021, the FDA essentially made it easier to obtain mifepristone. Eventually, the FDA said you don't even have to go into an in-person appointment. You can use it up to 10 weeks of pregnancy instead of 7 weeks. You don't have to have the same types of warnings. It doesn't have to be prescribed by a doctor. There was a lot of loosening of how you could obtain mifepristone starting in 2016. And the trial court judge tried to basically pause all of that. And that's where we are now. The Fifth Circuit agreed with that. So they disagreed with suspending the initial approval. At least for now, mifepristone is still approved, but we're operating in a world as if it's 2015 and it's just harder to obtain.
Yeah, and more than that, I mean, it's really upsetting kind of expectations in the way women have come to use the mifepristone and the other medical aspect of the termination procedure, which is now used in more than 50% of the cases. So, all right, well, and maybe we need to double back, and we will to what Kacsmaryk said, but basically now the Fifth Circuit is saying as to that things that happened in 2015, 2016, we won't grant a stay, meaning it is now the law. And so if this were to stand, the all kinds of settled expectations, including ones that the DOJ has stood behind about how you get mifepristone and when you can get it, would be out the window. So it would really very much cause, I think the language of the stay is irreparable harm. How did this is maybe putting too much on you, but how did the Fifth Circuit purport to draw the line between saying we'll permit the old part of the law to stay in effect, and this is all, of course, while the decision's being on the merits decided, but we will right away agree with Kazmarek that the newer part of the law and what the FDA did is been struck down. We won't stay that, meaning that for as of now, that part is no longer operative.
That's right. And, briefly, they basically said that we think the FDA cut corners. We don't think that they followed proper procedures. And they really questioned the data that indicated that mifepristone is actually safer than Tylenol. So, what the FDA had argued is when we made those decisions, when we loosened the restrictions in 2016, we had 15 years of adverse effects. We were able to look at the data. And the judges just simply weren't buying it. I think what's actually notable about the stay is that the one judge who was appointed by George W. Bush would have put the entire trial court ruling on pause while the case proceeds. He wouldn't have done this kind of half-half. But for the two Trump appointees, what I really saw, and Harry, maybe you saw something different, but I really saw them question what the FDA had said and basic facts about what the FDA has claimed about the procedures that they followed in 2016 and then again in 2021. I think for context for people to remember, mifepristone for a long time was subject to far more restrictions than other types of medication. And we have for a long time treated it as different. And then, Harry, we probably want to get to the legal wrinkle of, so the Fifth Circuit does this kind of half-half, but then we have what's going on in Washington. A federal judge there saying something different for 17 states and the District of Columbia.
Yeah, so it does get a little confusing, but hang with us, listeners, because we really can clarify. So let's just first go to Jessica, how the DOJ has responded to the Fifth Circuit stay, and I should add that the Fifth Circuit is known. This was all well engineered by anti-choice groups because they were able to file in Texas knowing they would get this single hostile judge. And the Fifth Circuit also considered very conservative. And the Supreme Court, of course, may be hostile as well, but there's no way around trying to go there. So the DOJ, and all this is developing very quickly, right? So the stay, partial stay, half-ass stay, can I say,
Can't to
what
me.
is entered this morning, and DOJ responds quite promptly, and the AG himself issues a statement. So what's their plan?
So they're going up to the Supreme Court and they say, no, we need a full stay. So they're going to appeal that portion of the Fifth Circuit that essentially allows part of the trial court judge's decision to go into effect, meaning they're going to say, no, we need to go back to where we were 2 weeks ago, where mifepristone is not just available as if it's 2015. Mifepristone is available by mail. You don't have to go in person. And that the changes that the FDA made in 2016 and 2021, those are entirely permissible. And there was some question in my mind as to whether or not the Department of Justice was going to live with, as you called it, I think perfectly, the half-assed stay. And they said very quickly, no, we won't.
Very quickly, right? And they need to get 5 votes to get a full stay here in the Supreme Court, failing which they just have to try to fight it, on the merits. I guess, well, now maybe comes into play the fact that we had a contrary ruling from a judge in Washington. So we have one district court where guy saying, throwing it all out. And remember, this isn't about abortion and right of privacy. This is about whether the FDA did its job Yeah, and it's all kind of Alice in Wonderland because they did this is 20 years ago, at least for the district court, and we've got a long record of safe and effective use of mifepristone since. But he's saying back then it was flawed. The Court of Appeals is saying as of 2015 it was flawed. Okay, so we have almost minutes after the district court in Texas, you have a district court decision in Washington. What did it say? And what do you do when you have two conflicting district court opinions like this?
So, what did it say? That district court judge who was appointed by President Obama said, keep the status quo, FDA. Don't change anything. Don't make it more difficult to obtain mifepristone. And so, you do have two decisions that seem to be pointing
Right.
in the opposite directions. One thing I was going to mention, Harry, I'm curious for your thoughts on this. The idea of the FDA being able to exercise enforcement discretion. So there's an argument that technically speaking, you can kind of comply with both rulings in the sense that the FDA can say, thank you to the judge in Texas, Judge Kaczmarek, but no, we're not going to enforce that. And that would set a whole different kind of precedent when it comes to executive agencies. So maybe there's this window of it's not just all up to getting five on the Supreme Court. I don't know where you stand on this idea of the FDA exercising basically enforcement discretion.
Hey everyone, we're taking a quick break to ask you to take a second to like and subscribe. It's a quick thing that really helps the show. Thanks, and back to the video. And we just have to remind everybody this is about administrative law, or it's really about abortion, but cloaked in administrative law. So it is true that the FDA, like everybody else in the Department of Justice, makes enforcement decisions every day. A good analogy is the DACA case, in which the immigration authority said, look, we're just going to choose. We got limited resources. We're not going to go after people who have been there since they've been kids, etc. And we've got bigger fish to fry. You could say the same thing here. Pro-choice advocates are urging the Department of Justice to do exactly that. I think the state of play is Department just doesn't want to do it. It really does, as you say, Jessica, invite a real kind of confrontation with the courts, and they want to look like they are law abiding. Of course, it's a quandary because law abiding according to which law? But they could try to say, because hovering on over this is the prospect of a different controversial con law doctrine, which is the ability of a single district court
Right.
to enjoin a practice nationwide. So they could try to say, all right, we won't let this happen in the Western District of Texas or wherever it's from, and otherwise we'll continue the status quo. But that is inviting a fight, and it does make them look like they're being partisan. So it's something they're hoping to avoid. On the other hand, if the Supreme Court doesn't give a full stay here, it really has changed things a lot on the ground. And this is a real, I mean, the DOJ early came in and said, issued a kind of directive saying, look, nothing in the Dobbs decision means people can't get approved drugs through the mail. Maybe you send them to Texas, and the Texas police monitored and burst into the home and arrest a young woman, but at least they can be sent through the mail. And that's really, become something that's been relied on by over half the abortions. I'm actually are way down since Dobbs, but the ones that are going on, over 50%, are through this process. So this is a really big broadside attack. Okay, all of everything we've been talking about so far is just about a stay. Do we, while this issue is being decided through the courts, let the FDA continue to say, or let mifepristone be used as it has been and it's been shown to be effective, or do we not let it and instead change everything while we decide things? So let's go to the merits for a moment. So Kaczmarek two things, or he said he would grant a stay, but not for a few days. That's why the stay part is all working out. But on the merits, his ruling at least was to throw it all out and say that the FDA had erred. Well, he said two things. He said that the challengers here have standing to bring the claim. I know this is a fairly legal little conversation, but it's unavoidable. And he also said that the FDA made a mistake, and in fact, it has to be back to the drawing board, which at the time took, I think, 4 years originally. Let's start with that second part. What did he say the FDA did wrong in terms of the substance of the law that made him conclude that the approval that it's been given is, has to be thrown out?
So, as I read it, what Judge Kaczmarek did is basically adopt the challenger's brief and change the language and say that the FDA fast tracked this, that they cut corners, that they didn't go through the proper procedures and hurdles that they needed to. And
And we're talking in 2000, right?
back in
Yeah.
that original approval in 2000. Um, Throughout the opinion, I think it's maybe important to point out here that Judge Kaczmarek really adopted the plaintiff's not just argument, but also their language. So he talked
Yeah.
about chemical abortions, not medication. He talked about abortionists as opposed to doctors. And he said, I believe, Harry, it was the very first footnote. He said, I'm not going to mention a fetus. I'm going to say an unborn human or an unborn child. So, yes, that
Which I'll just stop for a second. That wigged me out. No hostility toward religious groups, but that's a position that is hotly debated, and it really is the whole ball game. If the fetus is not just alive but but a person, then all kinds of rights follow. So he would have decided this by a wave of the hand. And since you mentioned the footnote, I'll say he said he would do it because other jurists have done it, and then cited one person, a scholar, a very noted far right wing scholar who was not even a jurist. So that really did show his hand. I think as as his former career had revealed, he's a very staunch anti-choice figure. But go ahead. So now he gets to the
well,
merits.
and the reason that I mention that is because that, to me, his view is something that just pervades the merits. Because let's
Yeah.
be clear, we've never had a situation where a single federal judge has been asked to reconsider the FDA's approval of a drug that, again, we're looking at a quarter century of use and data. And so, if when you read through that initial part of the opinion, not the standing part, but the merits part, it just seems to me that it factually adopts all of the arguments that the challengers make here, many of which go against the facts that the FDA has put forward about how they went through a rigorous, I think you mentioned already, 4-year process of approval. And of course,
Which, if I can interrupt, has been substantiated by, there's an Alice in Wonderland quality of the opinion where he's talking about what they did in 2000 and ignoring a 20-year history that showed the FDA to have made the accurate decision. This is where, whether it's as safe as Tylenol or, it's obviously been very safe for millions of women. So,
Right. And we can't pretend that that doesn't exist. And then, of course, and, Harry, I don't know what you think about this. He resurrects this 1873
yeah.
law, the zombie law, the Comstock Act. The Comstock Act originally prohibited mailing both materials related to contraception and abortion through the mail. Now, it hasn't been used for about a century, I think almost a century now, but it's been limited in important ways. One, Congress took out that part of the act that that referred to contraception. The other is that there are circuit court judges who have said, to the extent that this applies to the mailing of materials related to abortion, only unlawful abortions. And I think serving up potentially a textual argument to members of the court, like maybe Justice Gorsuch, Judge Kaczmarek here said, I'm looking at the plain language of the Comstock Act, and it looks like it would prohibit the mailing of abortion pills. Now, of course, if you read this broadly, almost everything that is used in an abortion in some way is mailed. And so this could have really broad implications. And, in my mind, it feels like resuscitating this zombie law that we all felt had been dead and gone. And, of course, there's a lot of chatter of it's 2023 and we're talking about an 1873 law here.
Yeah, and just imagine that is forbidding like the mailing of truthful information, and whether the abortion is unlawful is it's a bootstrapping kind of point because that's the question in the first place. Okay, look, I'm really thinking objective terms. This is a very sort of tendentious advocates piece, as you say, and another really important way that you would think good conservatives would be opposed to is a big reach in the standing doctrine. So let's just talk about that briefly. It's the doctrine that says you need to show that you've been injured personally to come in and sue. Now it's pretty clear about well, of course the doctors have been they're engaged because they're part of the lawsuit, but of course they've got a real skin in the game, as it were, as do women. What's the supposed skin in the game that the plaintiffs who are anti-choice advocates have justifying their deploy of the federal courts,
Yeah. So this
according to Kaczmarek anyway.
Right. So the standing part of Judge Kazmarek's decision was actually a big chunk of that 67 pages. I think because he had to get past what we understand to be our standing doctrine, which, as you said, you need an injury before you walk into the federal courthouse doors. And what we see here, I think, is a judge just rewriting the standing doctrine. We know for standing that you need an injury and it has to be concrete and particularized. And we need to show that there's causation, that the government action you're complaining of actually caused that injury, and that there's redressability, that if you win, there will be some remedy to your injury. And in this
And conservatives, starting with Justice Scalia, have taken this very, very seriously as a kind of pushback against what has been the use of federal courts by different groups to try to get, make policy decisions rather than redress injuries, or both, even.
And we've seen, in my view, we've seen the Supreme Court really punt on some big cases and say,
Yeah.
oh, but there's no standing. I mean, I'm thinking of the election law area where the court says nobody has the standing to bring cases like this. But when it comes to this case, I think there are two groups where I looked at Judge Kazmarek's analysis for standing. And I thought this is really strange. So for the medical associations and these larger groups that are suing, the judge, in my view, essentially said, well, they have to stand in the shoes of women who would otherwise sue because they've gone through this very traumatic event, and we can't expect them to be able to file a lawsuit, which is, again, not the law and not my understanding of an injury that we have ever allowed is this kind of third party, well, we'll stand in for you because you're simply not capable of bringing the suit yourself. And then for the doctors, I think it was also very strange in the sense that it's basically the argument is we might have to at some point treat somebody else's patient who had a side effect from mifepristone. Now, again, Harry, I don't know what you think about this, but if that's true, if the argument can be that the injury in fact is a doctor essentially doing their job and treating patients because you can somehow tie that to a government action, I mean, how far does that go? Can we tie doctor standing to an EPA action? Again, not my understanding of what the standing doctrine is currently.
Yeah, I mean, Katie barred the door, but especially because it's not simply that it's attenuated, but it's so speculative, the very kind of possible injury down the line that the courts rejected. All right, so this is a tangled web, but all these pieces really seem to play a part. I'm going to try to take a deep breath and summarize where things stand, and I want you, Professor Levinson, to correct my exam, and hopefully I get at least an A minus, and you can correct it going forward. But so we have a challenge from people who really don't seem to be injured themselves. And that's a requirement in the first instance. And they are able to choose because of the way Texas works. They divide the vast state into individual sort of areas that have single judges in them. And in the part where they brought their lawsuit, you have, conveniently for them, knowingly for them, a very staunch anti-choice person. That shouldn't matter for judicial opinions, but of course here it really seems to have. Judge Matthew Kacsmaryk, and he, one, accepts the claim. Two very controversial aspects to his opinion. He accepts the claim that they have a real injury, and then he says the FDA, as an administrative law, this is not abortion stuff, he says the FDA messed up, didn't follow proper procedures, therefore their approval of this drug that has been efficacious for 20 years is now precluded, and they have to withdraw or not act on this approval. That's the ruling. Then he says, but well, so that is going to have to be reviewed in one fashion. The immediate fight, though, is what's the state of play while it's reviewed. He gives a few days for the Department of Justice, which is in here saying, I represent the FDA. We did everything fine, and you should not withdraw approval. And they indeed move for a stay in the Fifth Circuit, very conservative circuit. And that circuit says, well, we will not grant a stay. In other words, we'll keep the law in effect for the original approval, but we're going to keep the Kacsmaryk's disapproval of it for the recent action, and in that sense, really completely change the facts on the ground while this is being decided. And the Department of Justice says, no, that really causes irreparable harm to women and doctors. We're going straight to the Supreme Court, and the state of play is they've asked the Supreme Court to grant the stay. So if the Supreme Court grants the stay, then we can proceed to adjudicate on the merits. I think it's a little uncertain where it would go immediately, especially with this Washington wrinkle. We can do that another time, but now we'll decide whether Kacsmaryk was right about standing, was right about the Comstock Act, was right about the FDA procedure and the like. So the immediate fight is, how are things today and tomorrow for women and providers? And is their world been completely upended? And then the actual administrative law claim involving the FDA. And this, again, to get back to where you started, the procedure of choice for over 50% of abortions in this country now. So a huge assault on what, notwithstanding the Dobbs opinion, is what remains supposedly of safe and effective abortions in the wake of the overruling of Roe v. Wade. What I miss?
A+ asterisks.
Okay, good enough for now. Good enough for government work. All right, so we'll be following very, very closely what the Supreme Court does, and probably in short order. It has to act, right, by tomorrow, I think, because that's when Kacsmaryk has said he will impose a stay. So this is all moving fast on the stay front, and how it moves on the stay front will determine how it moves on the merits front. So you and I think, are going to be back here with some more things to tell to our audience. Until then, thanks so much for being with us, Jessica, and I'll talk to you later, and listeners, talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.